Hello, everybody. Today I'm going to talk about a very newly established organization about which nobody is really talking on the media. I know the world is already preoccupied with so much going on, the wars, the trade wars, different world zones, having almost a Cold War situation between countries, big powers. But let's talk about an international mediation court which has been established in May 2025, and nobody knows about it yet. Well, maybe the people who are concerned, they will know, but from the students' perspective, the people who are in the field, nobody has really paid much attention yet because it's really 2, 3 months old baby. This is called International Organization of Mediation. It is the brainchild of China, but many countries have joined it, and many are talking that it may become almost at par with Permanent Court of Arbitration, or perhaps even better than International Court of Justice. So let us talk some basic points about it. The purpose is to, of course, peaceful settlement, but between whom? It is going to provide state-to-state dispute resolution. And you know, there are 192 plus countries in the world and so many conflicts around the world. And mediation is almost like we can say that state-to-state mediation is going to be mixed up with a court settlement, but with the features of a political settlement through arbitration, perhaps. Arbitration in the world is used usually for the commercial disputes between different parties, but this court has been called mediation court. They want to solve the disputes between the states, and not just between the states, nationals of other states and the states. So this is a new feature, which means that the countries will not only be able to sue each other's governments, but the people, the nationals, you know, who are holding nationality, individuals, they can be corporate persons, they can be human persons. They will also be allowed to bring claims against the states or other governments in this forum. It will be solving commercial disputes between private parties. So private parties can be anybody. They can be the groups, they can be the class cases, they can be individuals, you know, states in their personal capacity. Plus, it is also going to provide services for intergovernmental organizations for solving international disputes through mediation. Now, what is the current status? The status is 33 countries from Asia, Africa, Latin America, Europe have signed the text, the basic treaty, including China. And it is also the repository of this convention. So International Organization of Mediation, IOM. Many people confuse this word or synonym or this abbreviation of IOM with International Maritime Organization or International Organization of Maritime. This is why some law people have not really paid much attention to it. But its signing ceremony was held in Hong Kong. More than 50 countries, delegations participated. 20 international organizations participated, including UN. It means United Nations actually approves this forum. Now here is a logo. It's a blue-colored logo with the building image in the middle. And a mediation. I hope that people who are watching this, they will know what is mediation. Mediation is a settlement through peaceful methods and usually involving a third-party intervention. In common law terms, mediation basically means that when two parties themselves have tried to settle a dispute and they have come together, but their personal efforts have failed, then maybe involving a third party to whom everybody is ready to listen to, and the solution that person or that party gives will be given respect. So this is mediation. But here, of course, this is going to be a legally binding forum. So mediation or court words are being interchangeable. Why? Because there is already an ICJ, International Court of Justice, and in Permanent Court of Arbitration. So they don't want to use the word court or arbitration court. They want to use mediation, and they want to have a little bit of differentiation with other courts, so they want to call it organization. But actually it has all the legal features, and we'll discuss it later. Here is a building which is going to be used, or which has been assigned to be the head office of IOM. It is located in Hong Kong. So this building is actually an old building, and it has been now given to IOM. Now, who can be the mediators? Mediators will be, of course, people who will be sitting as judges, but then all the normal features of a mediator or an arbitrator, the same rules will apply to a mediator. Just like an arbitrator, mediator will be an impartial, neutral person who has the ability to treat people, parties with fairness, no conflict of interest when they are hearing the cases. They will be respecting the confidentiality, especially the state-to-state disputes, because states do not like media attention, especially if they are about to lose a case. So they do not want to be embarrassed. So confidentiality, of course, is a very important code of conduct. And the proceedings should limit only to the subject matter. They should not digress to other problems which may be there, but the states do not want the opinion of the mediators on that. But the detailed code of conduct, as the time passes or as one or two cases will be heard by this court, we will become, adopting more and more rules of conduct. The mediators, just like the judges of ICJ, will have all the international facilities. They will have international legal personality, because of which they will have immunities, which means they will have diplomatic immunities. And the day-to-day work or the management is going to be governed by a governing council, who is going to make the policy strategy by this for the court or for the organization. And one representative from each contracting state will be the governing council member, and they will meet annually. So once a year, this governing council, right now, let's say 33 countries are signatories. So 33 members or nominated people will meet once a year. Now, this is important. What are the principles assigned on the basis of which this organization is going to work? Well, IOM is going to work according to the principles of all the public international law, which is respect of the sovereignty and territorial integrity of the countries, equality of the countries, no matter big or small, rich or poor, all the countries, when they bring their disputes, they will be treated equally in front of the law. And the mediators, as I said, will not digress into other matters which have not been asked to be adjudicated. So there will be non-interference in the internal affairs of the state, and the cases will be heard according to international laws and their rules. Of course, the basic purpose of international law is to resolve the world disputes peacefully and to avoid wars. Then the IOM mediators will ensure party autonomy and free choice of means in the dispute settlement. What does that mean? We will come to it later on. But all the proceedings, the decision making will be done in good faith. And this applies even to the parties which will bring their cases. So the parties should not have any ill will or mala fides in starting a case. they should really be seeking settlement. So good faith, spirit of cooperation for an amicable settlement is needed from all sides. Then impartial, neutral, equitable environment has to prevail, which means no party should feel sidelined or cornered. The approach should be flexible, efficient for peaceful settlement of the disputes. Now, based on these principles, what is this court or this organization going to provide? Services of mediation. So it will be an international mediation center. It will be providing best practices of mediation, which obviously will come through research and through practice and through experience. But it will also organize conferences to share ideas, to share any experiences. It will also, through its work, be promoting cooperation for capacity building in mediation. Capacity building in mediation means that the people who can be mediators, we do not really want very hardened law judges or retired law judges who have very little flexibility. We want mediators who are going to be fair, impartial, and maybe not so strict. So equitable settlement, amicable settlement needs some training, and of course it needs some personality traits. Then communication with all the international organizations and agencies will be facilitated. Nobody is going to stay angry with each other. Now, if a dispute comes, the organization will have two panels of mediators to choose from. One set of dispute is between the countries who are sovereign, and they will have a set of mediators only for the countries, for independent full states. But then one panel will be for disputes between the states and nationals of other states. So here is a mixture of international and public international and private international law. So commercial disputes between private parties, like two companies, they will also have a separate set of panelists, of mediators. Obviously, why do we have this difference? Because for states, which may be more sensitive and more politically motivated, so there will be a separate set who have this mindset of giving opportunity to the states to feel that nobody is being favored. But for the commercial disputes or disputes between the private parties, we need to look at the dispute rather than the positions of the parties. So this is the reason we have a two set of mediators. Now, who can be a mediator? Well, of course, the first thing is the personal traits. The person who is well recognized in the competence of law, commerce, industry, or finance. And most importantly, who is well respected, whose character is, well known, and people have full trust in his or her personality. Now, persons who are involved in state-to-state mediations, they have to be also people with the background of law, especially international law, diplomacy rules, international relations between the countries, international political and economic affairs. They should have a general know-how about the world affairs, and political skill and judgment. As I said, the state-to-state conflicts can be hard to resolve because the states are going to be very tough in their positions. So the mediators here will have to really be not only the mediator but also a negotiator between the two parties. But in any case, these mediators, participants in the mediation, will have immunity facilities so that they can have a freedom to work. And they will have immunity from the legal processes while they're traveling, but also when they're working and sitting as a judge. What if they make any comment or a remark, or they write down something during their participation in the mediation proceedings, which may be taken as offensive by a party, but no legal action can be taken against them. Now, Designation. How do we find these mediators? First is the states, the governments. They can send up to 5 members or their nationals to the panel of state-to-state mediators. And the governing council may designate up to 10 persons in such a panel for state-to-state mediators. So the right for the first type of panel is for the governments to send the most suitable people they like. And for the general panel, for private or national persons, up to 20 of its national, the states can be sending up to 20 persons, or 30 in case of founding members. So it means the 30 signing members who have signed in May 2025, all of them will have a right to send a representative, which will be totaling up to 30 members, to the general panel of mediators, which means up to 20 persons to the general panel of mediators. So there are 20 or 30. And who should be nominated? People who have regard for all types of legal systems around the world. There should be a variety and diversity based on geography, based on the legal systems, and gender balance. And these mediators will work for a period of 5 years, which is renewable, which means they can serve up to 10 years if the system of renewing their membership is supported by the contracting states. Now let us come to state-to-state disputes. The organization of mediation will be looking at legal and factual disputes, not political disputes. So sometimes even a political issue can be a factual issue, just like, ICJ. You cannot bring political disputes to ICJ. It has to be an international treaty which the countries have signed, which is a legal contract that can be brought as a dispute if there is a misunderstanding or a difference of opinion. In the same way, International Organization of Mediation will only take law-based problems or factual-based problems where there is a difference of opinion, or there is a disagreement on issues of concern between the contracting states and they have requested a mediation so that the air can be cleared and there can be a third party clarity and a decision on who is right and wrong. And non-contracting states, well, they can also apply, and obviously IOM shall be welcoming all these non-contracting states and international organizations because it will show that they trust this organization. Now, third state where a dispute involves a country which has either not signed the convention or has not applied for a dispute settlement, what about that? Well, in that case, the third party consent will be sought so that the case can be taken ahead. For example, the dispute between India and Pakistan related to Kashmir involves China also. But if India and Pakistan take this matter to mediation without China, that will be a problematic issue, and IOM will have to seek consent of China also. Now, what about nationals of the countries? Usually this is a private international law problem, and this is a good thing that IOM is going to welcome even the private international law problems. So commercial or investment disputes between a government and a national of another state, or just like a company, they can use the services of this IOM. Even non-contracting organizations can come into this service. Then comes just the private parties, no state involvement. This is a unique feature. Even the private parties can bring their international commercial relationships in this organization. Of course, the personal or family problems cannot be brought in, but commercial disputes between private parties can be heard in IOM. Now, what is not allowed? Which case will not be entertained? Well, territorial disputes will not be entertained. Maritime delimitations like international maritime zones and international waters, they will not be a subject of debate in this organization. any issue which is unsuitable for mediation. And of course, this will be decided as this organization continues and as maybe the world starts evolving more and more rules for this organization. Now, because this is a settlement of a dispute, of course, evidence will be needed. No party in any other proceedings can rely on the views or statements which are expressed in other forums, okay? Uh, Especially, political statements, admissions, or offers of settlement made by other parties. No party can rely on that. Okay, so it has to be based on merit that you win or lose your case. You do not say he said, she said. And the report or any recommendations cannot be used as an evidence. For example, you have appointed a United Nations observer and they have given a report. This is not going to be the basis of decision, because United Nations reports will not be a basis of evidence of your claim, because obviously the report will be contested by the opposite party. They can reject it. And then let's see, this was a brief tour or brief knowledge or information related to IOM. What is the future? Many law students say that what has ICJ attained? What has PCA attained? We see the world full of wars again. Well, yes, there are geopolitical tensions. There is a risk of global trade war due to the current president of United States. Therefore, we can see that if the states, if the private nationals, or if the private individuals are affected by the world trade war right now, and only countries can go to ICJ, private companies or nationals cannot go, why not use IOM? So there was actually a survey done by Queen Mary University of London in 2025, and many said that they have more trust in Singaporean and Hong Kong legal forums rather than ICJ or any other international settlement forum. So, well, Hong Kong is offering this service, and the world has shown that they trust Singaporean forums or Hong Kong forums more behind London, okay, for arbitration. So why not try now the mediation? Thank you for listening.